So what happens when two family members own a property and one of them dies? My name is Andrew Ayers. I'm an estate planning and business law attorney with offices in Edina, Minnesota and New York City. And today let's take a quick look at a situation that comes up quite commonly when you've inherited property with your siblings and now one of them dies. So as I said in the intro, it's a pretty common situation. And what that is that let's say you and a family member or multiple family members have inherited a piece of property from your parents, let's say. So in this case, we had a family vacation home. Let's say it's on the beach in New Jersey, and you and your siblings have inherited it. And there are three of you. And the question is, what happens when one of you dies? So let's say the three siblings own the property together, and now the oldest one has died and the two siblings remain. And we'll also look at what happens then when the two siblings have died and only one sibling remains. The place that we're going to find our answer to this question is going to be in the deed to the property. The reason is we need to figure out what kind of title do you and your siblings own to that property. There's going to be two main types that we're going to run into. The first one will be a joint tenancy with a right of survivorship. The second will be what we call tenancy-in-common. And as you're going to see, depending upon which one it is, has a big impact upon your interest in the property and how you create your estate plan. So we'll go back to the first one, which is called joint tenancy with the right of survivorship. So in this case, you and your two siblings all own an equal share of the property. And what happens when that oldest sibling dies is that their interest is automatically passed to the two remaining siblings. And then when the next sibling dies, the remaining sibling who is alive actually owns the property 100%. So if we have an older brother, Adam, we have a middle sister, Betty, and we have a younger brother, Chris. In this case, if Chris is the last one who's alive of the three siblings, then Chris is the 100% owner of the property and can do with that property what they want in their estate plan documents. Now, even if Adam and Betty had created wills that said they want the vacation home to go to their children, if you have joint tenancy with a right of survivorship and you die first, doesn't matter what your will says. You can't pass on that ownership right in the property. Instead, it will go automatically to the remaining siblings who are alive. So you can see this is very important if you're creating an estate plan and you're dealing with a family home that's been in the family for generations. If we own it with that right of survivorship, your children may not be entitled to inherit anything from that property if you're not the last remaining sibling. So that's going to bring us to the other type of ownership, what we call tenancy-in-common. We'll have our same situation here. We have Adam, we have Betty, we have Chris. They're tenants in common. And what that means is they each own, let's presume, 1/3 of an interest in the property. Now, the other advantage with the tenancy in common is you don't have to own it 1/3, 1/3, 1/3. You could actually have Adam owning 75% and the other two siblings owning 12.5% each. So you can have an unequal ownership. Maybe Adam was the one taking care of the property over the years, helping out with mom and dad in the property, and mom and dad wanted to make sure that Adam was rewarded in their inheritance for taking care of the property and them as they got older. So if we have tenancy in common, that means that each of your individual shares can actually be given to your family as part of your estate plan. Now, you don't have to do it that way. You could have our three siblings again. They each have 1/3, and their will could say, my 1/3 share, when I die, goes to whichever of my siblings is still alive. So you can do it like the right of survivorship if you would like. However, what I find with most families in the tenancy-in-common situation is they would prefer that their share would then pass on to their children, so that their children can continue to enjoy that vacation home after they're gone, and it doesn't become this weird game of Russian roulette where the last sibling standing is the one who gets all of the vacation home. So hopefully you can see when we look at these two types of title, it's very important to understand if you have this ownership interest in a property, how are you holding that ownership interest? You may think that you can create a will that says my share in the vacation home goes to my kids, but if you're in a home with a right of survivorship and you have other siblings involved and you die first, your kids may not be able to inherit that property. If you have more questions or you'd like to talk further about this, you can go to my website, 𝙃𝙀𝙍𝙀𝙀. There's a red legal strategy session button on the main page. You'll be taken to my scheduling page where we can set up a 15 or 20 minute legal strategy session to go through these issues and see where you are in the process and give you some ideas for some next steps. If you like this video, I'd love it if you hit the like button or the thumbs up button below. You can subscribe on YouTube and check it out at ayerslaw.tv.com. And if you like this video, I hope to see you in future episodes on the channel.